the judge in the case in New York. Judge Lewis Lehman has granted the consolidated defendants of against Wayfair, Lively, Sloan Reynolds, and the New York Times. All of them they're granted in the motions to dismiss all but 2 claims that were filed against them related to a torturous interference in a contract with WME and Justin Baldoni, and the breach of implied contract between Blake Lively and Wayfair for the film. Those are the only counts that the judge will allow them to amend. Everything else is off the table. So right now as we stand, he has dismissed everything against Blake Lively, Ryan Reynolds, Leslie Sloan, and the New York Times. I guess what kind of shocks me about this, and maybe I shouldn't be shocked, and it could just be the way that this was pled with all of the different pleading defects, and with the group pleading, but also there's so much missing in their complaint. Because we don't have any information about this subpoena or how they got the text messages from Jen Abel's phone. But the problem here is that the judge isn't and doesn't care whether or not the evidence in Lively's complaint is valid or not, and the judge doesn't care if they're out of context. He doesn't care. He is deciding that what she put in her complaint is enough, and they didn't respond accordingly, and they can't overcome some aspects of this, which I think is really wild because it's almost like he's making statements of fact, but he is granting it, and he says that their Reynolds, Sloan's, and Vision PR's move for attorney's fees is denied, so they will not allow attorney's fees, and Lively moves for award attorney's fees, and he is denying that as well. It didn't take into account anything to do with 47.1. It wasn't relevant for his ruling. Something I found interesting is that on page 37 of the motion to dismiss, which by the way is 132 pages, the judge claims that Wayfair parties cannot recover for Lively's alleged actions to steal creative control of the film from Belden, and the Wayfair parties, regardless of the propriety of these actions, they do not constitute civil extortion under California law. California laws and courts have recognized a claim for civil extortion in situations where a plaintiff gives a defendant money or property under threat and seeks to have it returned. However, the Wayfair parties have not adequately alleged that Lively's threats were wrongful extortion rather than legally permissible, hard bargaining, or renegotiation of working conditions. Additionally, the Wayfair parties have not shown that Lively's alleged extortionate acts damaged them. He also says that they cannot recover on their defamation claims. The Wayfair parties have not alleged that Lively is responsible for any statements other than the statements in her CRD complaint, which are privileged. The Wayfair parties have alleged that Reynolds and Sloan made additional statements accusing Baldoni of sexual misconduct, and that the Times made additional statements accusing the Wayfair parties of engaging in a smear campaign, but the Wayfair parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on information available to them, as is required for them to be liable under defamation. Their additional claims also fail accordingly. The amended complaint must be dismissed in its entirety. However, they have leave to amend their claims for breach of implied covenant and torturous interference with contract. So basically everything that they filed against Blake in regards to any of the stories that were put out by Leslie Stone that we all know were not true, those apparently don't count. And Blake acting inappropriate and threatening and yelling and making demands is apparently legally considered hard bargaining. I think one of the issues at issue in this is that nobody attached the actual contract of Blake Lively. And is it because there is no contract right now? We don't have any contracts to review. The court doesn't have any contracts to review. They can only rely on what they were told by Belden about the contract. And without the contract as evidence, we don't know what was violated. I don't agree. Even if he's going to dismiss him, I don't agree that Heba Lalden wasn't defamed. I also don't agree that these tactics are acceptable. I mean, hard bargaining or renegotiation of working conditions hardly seems appropriate in as it concerns getting a second cut of the film. They're going to either need to provide a copy of her contract or show what the terms of the unsigned contract are as far as all of the issues. When it relates to all the different issues with this, what choice of law, he didn't even really decide which choice of law mattered. Basically, they say that they lost the civil extortion because this is what the judge wrote. The Wayfair party's civil extortion claim is based on allegations that Lively refused to return to production unless the Wayfair parties agreed to her return, to production demands, and that Lively threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the Wayfair parties agreed to co-fund a screening of her version of the film, eventually release that version, and grant her producer credit in support in seeking a PGA designation, and that she threatened to boycott the premiere unless Baldoni was excluded, and that Lively and Reynolds threatened to attack Wayfair in the press if they did not take the blame for the problems during filming. The last set of allegations is not actionable because Wayfair did not acquiesce in the threat and did not accept blame for problems during filming. Wayfair did not lose anything, and Lively and Reynolds did not gain anything from the threat. The remaining allegation must be dismissed because the allegations regarding Lively's wrongful threats are conclusory and failed to support that the threats were wrongful. In addition, the Wayfair parties have failed to plead that several key instances of alleged extortion caused actual monetary losses. They also allege that the only cost that the Wayfairs had to deal with due to her return to work was that they had to hire an additional producer that didn't benefit Lively and that they don't support. That Lively was attempting to extort Wayfair into hiring a producer, as opposed to seeking to confirm previously underserved terms and conditions, or at worst, seeking slightly more favorable terms of employment, even if they turn out to be unneeded. An employee can insist on protections at the workplace for sexual harassment without being accused of extortion. One thing that the judge kind of slaps Justin Baldoni's hands on is if Blake was doing all of these threats during this process, and if she was making demands, they could have at any time just threatened to sue her for breach of contract, and there would have been a remedy. And because they didn't include the contract between Sony and Wayfair when it came to who had the rights to make a cut of the film, and if 2 cuts were available, he's assuming that Wayfair had control over that. And so acquiescing to Lively and her demands is sort of like tough luck, buddy. That's your fault. And I don't disagree that there were definitely issues here that Baldoni could have fought back harder, and he didn't. But I think he was trying to balance the need for the film to get out. And, I think more than anything, they say that the extortion claims don't count. But what this tells me is that he's agreeing that Blake's behavior was threatening and was causing issues, but he's saying it doesn't mean that it's unlawful. She can be difficult, she can make threats, but she didn't get anything out of this. They also denied everything to do with the defamation, and the judge ruled that the New York Times had no motive to take Lively's side, and they might have over-dramatized what they believe they saw in the complaint, and they may have added sensationalism to it, but it wasn't with malice, and it doesn't also mean that he referenced that Wayfair was given an opportunity to respond and give their side, even if it was only limited. And then as far as Ryan and Leslie's claims of, these allegations of that he's a sexual predator, he stated that Ryan had reason to believe it was true, and so therefore he didn't make the statements about Justin being a sexual predator with malice. And because Wayfair hasn't done anything yet about the evidence or these text messages that Blake Lively has put in her amended complaint and how she got that evidence, what I think is interesting about the motion to dismiss is he's grabbing evidence from Blake's side of text messages that she has in hers and saying, well, Wayfair says this and Blake says this. And they basically were saying that what Wayfair provided them can't counter what W. Blake provided. For instance, in one example, they said general statements to the effect that they are doing all of this themselves. And We Are Doing FOL do not explain how a specific reference to Jed and his team's effort to shift the narratives towards shining a spotlight on Blake and Ryan would be anything other than a reference to negative publicity about Lively, nor does that fact that some of many articles were organic contradict that specific messages stating that Wayfair gave negative information to editors or boosted negative content article does not claim that the smear campaign was the only source of backlash against Lively. It acknowledges that it's impossible to know how much was negatively publicly was seeded by Miss Nathan and Mr. Wallace and their team. They're consistent with this view. There's no allegation that the messages suggestive of a smear campaign were inauthentic or that the Times ignored some obvious additional source that would have demonstrated interpretation of the messages was incorrect. They have a really high burden for claiming defamation, and because they have to prove malice because they're public figures and because they're saying the Times basically interpreted everything. They say the Wayfair party's complaint is that the overall smear campaign narrative is defamatory given the strength of the evidence and the favor of a smear campaign. It is not plausible that the Times entertained serious doubts as to the truth of the smear campaign narrative as a whole, even if for whatever reason it misinterpreted one particular set of messages in aid of that narrative, even assuming that the Wayfair parties prepared and laid the groundwork for a negative publicity campaign, but never in fact put the campaign into operation. The reference of using their own words against them and shining a spotlight on Blake and Ryan were innocuous. It is not plausible the Times would have known this. Now what is interesting here is that the judge in the case did not rule when it came to 47.1, nor did it rule when it came to anything related to fees. And he said that the court denies the motions without prejudice to renewal. This is related to the awarding of, tribal damages, punitive damages, and all of that. It says the court denies the motion without prejudice to renewal in accordance with the ruling. Here, the court has ruled that the law applicable to the claims against Reynolds and Sloan's cannot be determined absent further factual development. The court has not ruled on whether Lively statements were privileged under California Civil Code 47.1. If defendants choose to renew their motions, they shall fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing, so they can file for a motion for sanctions and trouble damages. But he said that he hasn't ruled on whether or not those are, statements of privilege, or he hasn't made any declaration of fact around that law. But for now, he's denying it based on what they've currently filed. Ultimately, the judge decided that Lively was not liable for anything because she didn't make any statements about Justin Baldoni and the sexual harassment outside of the CRD complaint, which they said was privileged, and he couldn't time. He couldn't tie Reynolds or Sloan to actual defamation based upon what they said about Justin Baldon, because it was their belief and they would have had to prove actual malice. But he will allow them to amend two claims. One is the interference of Belon's contract with WME, where the person, Mr. Reynolds, made comments that Justin was a sexual predator, but they said they need a copy of that contract. Justin's with WME to make the determination in whether or not there was an interference by Ryan, and they'll also allow them to amend on the contract between the implied contract between Blake and Wayfarer as it relates to the movie. And because, again, they don't have the contract, they can't make the decision based upon what they provided in their First Amendment complaint. And based upon what they provided in the exhibits, he's not going to allow almost any of these claims to be rep-led because he says that anything added beyond what they've already shared wouldn't give them grounds to actually be able to overcome the facts. And he does not view Lively's threats as extortion, no matter what they say. He calls it hard bargaining. That's how he refuses it. He says that incorporating these facts would not aid the Wayfair parties in alleging that Lively's threats were legally wrongful and could not be resisted in fact. And if in fact Lively did not owe the Wayfair parties an obligation to promote the film, her demands regarding what she would need in order to comply with their requests that she engage in promotion would not have been wrongful. They would constitute hard bargaining, and here's where Blake Lively found a loophole. She didn't sign the contract. If she didn't sign a contract, she had no legal obligation to do anything, so she could threaten all day long. And so really, to me, the lesson here for Wayfair is that you need to have everyone sign their contracts before they're on your stage, before you're filming. And you do not allow them to film anything without a signed contract. And she was able to get away with this because of that loophole. It doesn't mean that what she did was right. By any means, he just doesn't agree that it's extortion. Now he does. They can appeal this decision, and I honestly don't know if they will. But they said that there's no way that they can prove this was with malice. And the only two that he'll allow them to amend are ones related to contract. The court will grant leave to amend claims for torturous interference with contract and breach of implied contract. The Wayfair parties failed to plead the specific details of any contract between Belon and WME, but suggest that in their briefing that this defect is easily curable and that they will plead an oral or implied contract of which Reynolds was aware. Given the allegations that Reynolds told WME to drop Belden, it cannot be said that repleting this claim on such terms would be futile. Similarly, the Wayfair parties assert that they are able to allege the details of Lively's contract with Wayfair, including that her right to consult and approve on the film be exercised in a reasonable manner without seeing the contract. the court cannot say that amending the breach of implied covenant claim will be futile. So contract ones that actually had damages and dealt with specific terms, they can amend on. He's not going to award any fees here. He's not going to make any decisions on 47.1, and he's going to give them until June 25th to respond. He also noted that he didn't take into consideration any of the briefs that had been filed, and he made no decision about the anti-SLAPP law or the grounds or the constitutionality of 47.1. He just left it completely off the table. So naturally, Blake Lively is taking this as a win because it is. And they said in a statement to Variety, "Today's opinion is a total victory and a complete vindication for Blake Lively, along with those that Justin Baldoni and the Wayfair parties dragged into their retaliatory lawsuit, including Ryan Reynolds, Leslie Sloan, and the New York Times. As we have said from day one, this $400 million lawsuit was a sham, and the court saw right through it. We look forward to the next round, which is seeking attorneys' fees, trouble damages, and punitive damages against Baldwin Schwartz, Nathan, and the other Wayfair parties who perpetuated this abusive litigation. And Baldwin's team hasn't said anything. I don't know if they're trying to figure out what their next move is. This is a devastating blow, obviously, for them. Not at all. What I saw coming, and, I don't know what they're gonna do. They're gonna have to recalibrate here and really figure out what steps they're going to take. But I will make clear that the judge, in his ruling, said that he did not make this ruling based on anything to do with the law of 47.1. His ruling was based on he gave her privilege off of the CRD complaint. He did not give her privilege under the 47.1, and he took 47. One completely off the table by considering it a non-factor. So the ruling itself is, I'm giving her privilege based on these statements were made in a CRD complaint period. So their assertion that they're going to seek treble damages doesn't necessarily match. That he just said that the ruling is not based on 47.1, that might be a silver lining. So what does Justin's team have to do? Well, they have a couple options here. They can file an appeal with the appeals court to decide whether or not if they disagree with how the judge ruled on the merits and the statements of facts, or they can obviously amend their claims against Lively. Now, future amendments will also go through a process where Lively will absolutely file another motion to dismiss in a new filing. They could bring up new complaints, and they could bring up new allegations. As far as new charges, I guess, is what you would want to call them. Could they address the evidence of the 47 of the sham subpoena? Yes, could they look at abusive process? Yes, could they look at other counts that are SEs that are still considered part of this, but not the same? Yes, they can't bring up any claims in a countersuit that would be similar to what they already alleged, so they can't bring up anything about extortion. They can't bring up anything about defamation. Can they bring up the stuff about Van Zandt? As long as it's not related to defamation, yes, does the judge have to consider it? Maybe, maybe not. If he believes it will prejudice the plaintiff's Blake by adding new claims, he might discount them altogether. So they're really walking a fine balance here. But I would suspect that because they sent a letter a couple weeks ago that they were hearing all legal grounds as related to the Van Zandt lawsuit and the subpoena, my suspicion is that an amended complaint will be all about how the evidence was collected and the violations there versus the defamation. I don't know, but they're not going to be able to claim invasions of privacy because he already threw those out. So it'll be tough. You guys, there's no easy answer here. An appeal is also not a guarantee. And all it would really do is delay everything, because the appeals court would automatically pause the case on the district level until the ruling comes down from the appeals court. So I don't know what their plans are, but they haven't made a comment. And I'm sorry, I can't give you better news. But for now, this is how it stands today. They have until June 25th to respond, and I would definitely expect an amended complaint. Please like and subscribe.